There are actually a number of different mechanisms by which this strategy can be implemented. Either it can be an entity de novo, you create a social purpose business. It can be a for-profit subsidiary of a nonprofit. And there is also some room for conversion from an existing nonprofit into a social purpose business, which would be an L3C. So again, this is a situation which is a function of the specific enterprise's facts and circumstances, but I think there's lots of room to be creative in taking full advantage of this opportunity. It's all about leverage, and the extent to which pre-existing nonprofits wish to pursue this opportunity to create an earned income strategy so they become less dependent upon government funding, which is obviously problematic, and less dependent upon grants in their own right. This is a very useful supplement to those sources of revenue, in my judgment. I want to mention one thing that building on something Jen had mentioned. She said the Secretary of State had no problem. That's true. In Vermont, there was a conference with the Secretary of State there, and obviously they're looking at how much work is this going to be, what impacts are going to be on the budget to administer this. And Vermont, of course, is a little smaller state than Illinois. So the Secretary of State concluded, well, we actually do have to get another file cabinet. So there's great support for this concept, and not much against it. Yes, sir.
Would an investment from a not-for-profit to this new limited liability company, would it be considered a for-profit investment, or would it be hit under the unrelated business type situation for tax purposes?
Yeah, it can. It can. Now, understand, though, that we're not dealing with, in most cases, we're not dealing with an operating nonprofit, but rather a foundation. So those rules could, in certain cases, be implicated, in which event it may be useful to have a match between the social purpose business's purpose and the mission of the organization that's funding it, because to the extent it's in furtherance of the nonprofit's mission, it would not be an unrelated business. It would be a related business, and therefore not subject to unrelated business taxable income. Good question. Yes, sir.
On that note, is there any concern about foundation? Is the foundation required to eliminate PRIs in L3Cs or organizations that...
I missed one word. Could you? Sorry.
Excuse me. Are foundations required to make their PRIs or their grant making to organizations that further the mission for which they were originally founded? Or can you make PRI any L3Cs?
Yeah, no. If the question is answered by reference to the governance instruments of the nonprofit. Take the case of a family foundation, for example. Often their charters are drafted broadly to allow decision-making within the family to support different kinds of charitable causes. On the other hand, if the foundation happens to have articles of incorporation or a trust document which by design narrows the activities which are to be supported, then a program-related investment would need to be compatible with that mission, or they would be acting outside the scope of their charter. Now, that's different from mission-related investing, which is deemed to be portfolio, and therefore the decision-making is not constrained by that limitation. Rick?
Where is the status with the IRS with respect to recognizing PRI, which you mentioned?
Well, recognition of PRI came into the law in the Tax Reform Act of 1969. So it's been in the law a very, very long time. But for the reasons that I've described, it's been generally unattractive, and not too many organizations have availed themselves of it. The key is going to be the federal presumptive registration law. Right now, the Senate Finance Committee staff is working on that. I am told, candidly, the Senate Finance Committee is predisposed to deal with some other issues first. However, there are specific senators, and on the House side, specific representatives. I could tell you who they are, but I probably shouldn't, that are going to be attaching themselves to the bill. One of them happens to be an Illinois person. Two of them are Illinois persons, one on each side I guess I've given away one name, haven't I? So the expectation is that we have to get through the current unpleasantness, and thereafter this will be a higher priority. But everyone is strongly optimistic that this will all happen this year. Illinois will happen this year. The federal registration will happen this year. If you can't wait until Illinois happens, there's nothing preventing an organization from establishing L3C under Vermont law or Michigan law, and then registering it as a foreign LLC in Illinois. So it can be done today. Yes, sir.
Can we get a hold of your slides?
Yeah, I think what we're doing is we're going to be archiving the slides on the Social Enterprise Alliance website. Is that right, Daniel?
We can do that. Anyone who would like the slides, just shoot me an email.
Yeah, let Daniel Allen of my firm know about it. We can send it to you, whatever's easy for you. But I think it would be beneficial to have them available more generally, because I think one of the things that Social Enterprise Alliance wants to be doing is promoting this, because it's certainly compatible with its own mission. Yes, way back. There's no official cap. The thought is probably 5% or something like that.
So what happens if you stumble on some fantastic intellectual property or market opportunity?
Yeah, that's the beauty of this thing. I mentioned that this is to be an entrepreneurial activity, and the reason it's an entrepreneurial activity is, one, because entrepreneurship requires both risk and innovation, and this seems to be a reflection of both, but also because entrepreneurship can deliver outsized profits, and there's nothing disqualifying about that. The only thing is the venture cannot be organized with a significant profit motive in mind. If it happens, that's great, and my expectation is that any L3C in which I'll be involved is going to make a lot of money. Don't tell anybody. Yes?
Do you expect, in terms of layering these tranches of investment, do you see them as different rounds of investing, like a round A, B, or C, or different preferred?
I see them, yeah. It's a good question, Linda. I think it's going to be essentially concurrent investment where each is contingent upon the other, because the foundation may want to say, hey, I'll give you some seed capital and then go chase private sector money. That's certainly fine, but I don't see it working the other way. I don't see somebody saying, I'm going to come in as a socially conscious private investor, and you go find a foundation. I mean, I think there needs to be the underlay of the foundation money to support and entice the private sector capital.
They have ownership, and
yeah,
so
sure
full
can.
exit, but the exits on the top would be different than the foundation.
Exactly right. Just as you do in any LLC, you can have membership with different preferences, priorities, and rights, and may be coupled with employment agreements, may be coupled with board service, may be coupled with shared infrastructure. I mean, there's really lots of different ways of playing this. It could come in as debt, it could come in as equity, it could come in as a hybrid, essentially equivalent to a preferred stock. If you think about how complex a public corporation can be, all those same choices are available here. Not to suggest all of them will necessarily be taken advantage of, but there's nothing precluding it. And there will be exit strategies, because often, as I see it, the foundation will be there for a duration. It's seed capital to get the thing going and viable. Once the thing starts generating revenue and the obligations to private capital have been satisfied and are being satisfied on a continuing basis, I suppose foundation will often want to be bought out, and that may be built into the deal. There will be buy-sell kinds of provisions, because they want to be able to take their capital back. The purpose has been served. The social purpose will continue to be served, because they've now empowered the social purpose business, but now they get their cash back and they get to do the game all over again, as distinguished from a grant where here it is, it's gone. Difference between an expense and an asset. Key. Yes?